2023, and something that is new to us. So on behalf of the National Council of Churches in India, its leadership and the members in the Secretariat, I extend a warm welcome to each one of you. We are already 39 and people are joining. It's a Saturday morning. In spite of weekend, we are happy that you are able to join and learn from this webinar. I also extend a word of welcome from the leadership of the NCCI Commission on Policy and Policy Governance and Public Witness. There is one commission that deals with matters relating to law and matters relating to the government and relating the government to the church. On behalf of the leadership of the Commission on Policy Governance and Public Witness, also I extend a warm welcome to each one of you. Special word of welcome to Advocate Mona Marwa, who will be leading us in our discussions today, and also to Mr. Bertram Devdas, who will co-host this webinar and share with us the salient features of the Act. You know, Mr. Bertram Devdas was the National General Secretary of the National Council of YMCAs, one of the constituents of the National Council of Churches in India. Now he's the Director for Institute of Advanced Learning in St. Stephen's College. He himself is a trainer on Mediation Act, and he very proudly says that Advocate Mona Marwa was his teacher. And together they are hosting this webinar for us, and we are grateful to God for what they are and their ministries. I also want to welcome Advocate Ananya Marwa, who will be the technical specialist for this webinar from Delhi, assisting Advocate Mona Marwa. Going to court is not a bad thing, but it costs us a lot and takes a long time. Many people ask, why are there so many court cases in the churches? And I tell them it is because we want to make ourselves accountable to the public authority. However, if there are processes by which we can sort out things by ourselves, it is very welcome. And Mediation Act is one such tool that is available to us to sort out things among ourselves. And we hope that this new tool will be a blessing to all of us to sort out differences in our opinions, in our perspectives, the way we look at things, the way we interpret things, the way we practice things. And at the National Council of Churches in India, we thought, let us introduce this act to our people. And if anyone gets interested, we will have, we'll follow it up with training of trainers, so that across the country, we have a panel of people who are equipped with the skills of mediation according to the law. So this is a small step, I suppose, in the right direction, and seeing your participation, I think that it is something important for us. I see metropolitans of churches, I see bishops, I see senior priests, I see people who are secretaries of regional councils, I see heads of institutions, I see heads of networks, I see theologians, I see theological educators, and I see my own colleagues from the NCCI. And it is very encouraging to see that it is being welcomed by the church and the Christian organizations. And I hope that we will move forward in this direction. With these words of introduction, and thanks to my colleagues who helped us host this, in spite of this being a non-working day, I pass on now to Mr. Bertram Devdas to introduce Advocate Mona Marwa to us, and also the theme of the webinar. Mr. Bertram.
Good morning, and thank you, Reverend Asir, and a warm welcome to all the participants, distinguished members. Can you all hear me?
Yes, sir.
Okay. So along with me is Advocate Mona Marwa. She is a senior advocate and a mediator. She has completed law and she has been a practicing advocate since 1992, over 30 years. Plus, she has been a trained certified mediator since 2015, with an experience of over 2,000 cases in community, family, and commercial cases. She's been empaneled by the Delhi government, the Delhi State Legal Authority, the Delhi State Consumer Disputes Redressal Commission, the Mediator Senior Citizens Tribunal. She's been a former counselor with the Chief Minister Delhi Public Grievances, and also former legal counselor, NGO for Child Rights, the Kailash Satyarthi Children's Foundation. We welcome you, ma'am, and thank you. I will just share with you briefly how we will go about this. It's a 90-minute webinar. We will take about an hour between the two of us to make presentation, cutting across 6 areas. Ma'am will speak on the first 4 topics. What is mediation? Why we should go in for mediation? Third, how is it different from litigation? And fourth, what is the process of mediation? The fifth will be taken by me, that is advantages of mediation. And the sixth and the last area would be covering the salient features of the Mediation Act 2023. We will welcome interjections as we go along. We will also allocate a time of maybe 15 to 20 minutes towards the end for question answers. But there is something that you would like to ask in between, you're welcome. We hope to conclude by 12:30. So with these words, I will request ma'am to make the presentation. Thank you.
Thank you, Mr. Devdas. Good morning and a very warm welcome to all the esteemed participants. Today we are discussing on the topic of mediation. In a very simple words, I can explain mediation as a private compromise or a process of resolving disputes in an amicable way. So it is basically an alternate dispute resolution mechanism. That means whenever there is a conflict or a dispute arises between parties, they have an option to take this mode of settling their disputes rather than going to conventional mode of litigation and in the courts. Now, we all will appreciate that there is no doubt we have a very strong judicial system. But as we all know, there is a huge burden and backlog of cases pending in the courts, despite the best efforts of our government and the judiciary. The main reason is we appreciate that we are a country of a population of 140 crore plus people. Further, with the economic and industrial growth, the litigation has increased manyfold. At the same time, we have limited resources with respect to infrastructure of courts, number of judges, judicial staff, etc., to deal with the same. So this results in an inordinate delay in justice delivery system. Under our judicial systems, further, parties have a right to go for an appeal, for a review or a revision against an order or a judgment if they are aggrieved by it. As a result, this lengthens the final outcome of the proceedings. So the pendency and delay in final outcome of the legal proceeding is there. The process becomes very lengthy and expensive and tiresome for any litigant. Now, I respect the legal profession, but role of lawyers also cannot be ruled out. With due respect to the profession, they might, in their own personal interest, try to delay the proceedings. For their personal or professional interest, the role of the lawyers can also not be ruled out. Now, as a result of all these factors which I've mentioned, though they are not exhaustive, we see that there is a long delay in the resolution of disputes in the court of law. It is expensive and tiresome. You see, even with an honest litigant, because of these hardships, it makes him wary to approach the courts. It can, at times, a case can take about, say, some years, say maybe 10 to 15 or some more years. Increasing beyond 15 years also, we've seen matters pending in the courts. In case of property matters, we've seen that the litigants demise during the proceedings. So in that kind of scenario, we see that justice truly is not delivered. In the present day area of globalization, liberalization, and economic growth, you all will agree that we need an effective, inexpensive, and expeditious dispute resolution process. I think everybody will agree with me on this, which will help to an easy access of justice to the people. This will help us in having an ease of doing business and ease of living for the citizens, which is not doubtful. So it is in this context that we are turning to alternate forms of dispute resolution like mediation. I'll stop on this. Any clarifications or questions on this point? So we'll go more further. That mediation or other forms of ADR are not new to our system. They are deep rooted, and we will see that it is, if we see, go back in, it is deep rooted in our Indian socio-economic system. We are very familiar with the word panchayat. Now, in olden days, disputes used to be resolved in a panchayat, that is, matters is resolved at a community level, which is very similar to community mediation today. The disputes within the communities or tribes or religious sects were also resolved by the religious heads, like the priest or a Maulvi or a father of a church. People have been approaching them. Then in joint set of families, the head of the family has been taken as the neutral person who would resolve the disputes which are arising between the families. So the concept is not new, but it is being promoted and developed and being incorporated in our legal system today. As seen from above, to overcome the hurdles of pendency of cases and lengthy trials of the courts and government are encouraging parties to adopt the ADR mechanisms. Mediation is being widely promoted and accepted. Please note this point, that mediation is being widely promoted and accepted as a preferred mode of ADR mechanism because of its unique features. It is economical, it is efficient, it is a friendly and a very informal platform mechanism where parties, we are not getting into the complexities of court or pleadings or counsel, and it is time effective, it is time bound. So now, with this brief background, we will understand what exactly is mediation. I will be covering the topic in very simple and general terminology. And in case I'm repeating, if there is any question or clarity, you will be please free to interject or ask the questions in between, which would be more welcome. We would like it a more participative session. So now, what is mediation? In order to understand mediation, we will start with the definition of mediation, which is displayed on the screen in front of you, all the participants, for your reference. So I'll be just reading the definition now. Mediation is a voluntary, party-centered, and structured negotiation process where a neutral third party, known as a mediator, assists the disputing parties to resolve their disputes or differences in an amicable way. This is done by using specialized communication skills and negotiation techniques by the mediator. Now, I'll go further and analyze the definition stepwise for a better understanding for the concept of mediation. We say mediation is a voluntary process. By this, we mean that it is a free will and choice of the parties to participate in the mediation process, and they can withdraw at any stage from the mediation process. Now, it can be a court-referred mediation. It can be mandatory mediation under a law or an enactment, or it might be under an agreement between the parties. But in every stage, the parties are not bound to come to any settlement or non-settlement. It is a free choice whether they decide to come to a settlement and what are the terms of the settlement, or they do not want to settle the matter. So it is a very voluntary process. The second is party-centered. It is party-centered. So parties are the focal point of mediation. They have a complete control on the final outcome of the mediation. That is, when I say final outcome, whatever, whether they settle the matter or not settle the matter is the prerogative of the parties. And what will be the terms of settlement is also the choice and consent of the parties. So parties play here, we see a key role in statement of the facts, identifying their issues, generating the options for settlement, evaluating those options, and final decision regarding the settlement, as I've stated. We will going in the process, we'll be dealing more with these terms, which will make it more clear. I've mentioned here maybe earlier also, and maybe we will be saying it again and again, that mediation is a very friendly and a simple and informal process. But at the same time, the definition says it's a structured process. That means it is not a casual process. It has definite, identifiable stages of mediation, which a mediator follows, though there can be flexibility in following these stages. Now we come to, now this point is again a very important point. It is an assisted negotiation process. So it is not that two parties are sitting and negotiating. It is with the help of a neutral third party called the mediator, who helps the parties to come to a settlement. So we call it an assisted negotiation process. Now the mediator acts as a catalyst. His role is like he's acting as a catalyst or a facilitator who helps the parties to arrive at an amicable solution. He does not impose his personal preferences or opinions on the parties. He is not supposed to do, and he does not do in the process of mediation. Neither does he attribute any blame, responsibility, rights or wrongs on the parties. It is only that he encourages his role is only to help the parties to communicate, have a dialogue, help them to understand what are the issues which are a priority to the parties, moving them from a position where they have a stand to a solution base. So he helps them to generate the options for coming to a settlement. He helps them to evaluate those options in their interest. And then finally, in settling the dispute. So the role of a mediator, I'll wind up, is like that of a facilitator and as an evaluator. He has a control over the process, but he does not have a control on the outcome of the process. As I mentioned earlier, the outcome of the process, the control is with the parties because it's a party center. That is the settlement or non-settlement, and the terms of settlement is the control with the parties. But control of the process is with the mediator. I hope I'm clear on these points. Any clarification or... Okay, so another point where we talk of this processes and it is very important is that it is a neutral and impartial process. Any party goes to the court because they feel that they will be heard and there will be an unbiased decision with respect to the outcome of the case. Similarly, here, in order for the mediation process, there is confidence and faith in the process because it is neutral and impartial. The mediator acts as an independent person. For him, both the parties are equal. Further, the mediation process is private and confidential. It is not public, unlike we have it in courts where the proceedings are held in open. This takes place in a private conference room, and all the proceedings, whatever is exchanged during the process of mediation, any documents, any information, any terms of settlement, are not made public. They are confidential. So with this, we come to a brief overview of the process of mediation. What is mediation in very general terms I have explained. Now I'm going to make this into a comparison with litigation, what is taking place in our courts. So you see, in a court, when you go, there is a difference or a dispute with a party, and the parties go to a court. What first they need is a counsel, a lawyer. The lawyer then prepares pleadings like a plaint, a written statement, rejoinder, etc., which is submitted in the course of the procedure to the court to put their case. There is a element of court fees is there. So we see that this is a complex structure. It involves expenses. It is dependent, a third party, which is a lawyer, which presents the case of the parties. And the decision is by the honorable presiding officer or the judge, who decides the case within the limits and within the boundaries of the laws in force. Again, then it is adjudicatory process. Now, you see, it is based on rights and duties. So the outcome is favorable for one and maybe unfavorable for the other party. So it can be a gain or a win for the one party and a loss or losing or say not satisfactory outcome for the other party. Normally we see in litigation, the process goes like this. Again, from the aggrieved order, as I've mentioned, people can go into appeals, revision, review, which will take a long time. So we see that the process becomes very costly, lengthy, and a lot of hardships for the litigant to face. Now, in comparison to this, we can take mediation. Mediation is a very informal and a friendly process. The parties are participating and putting their case themselves. There can be lawyers. Lawyers are there in courtrooms in the mediation process, but even if they are not there, the parties can participate. So a counsel is not always needed. There is always oral submissions and oral dialogue between the parties. It is time bound. Normally, as per the new act, the mediation proceedings have to close within a time frame of 120 days. Maybe an extension of another 60 days, depending on the case. So we see that it is time bound. We wind up the proceedings by within 2 months, extension maybe to 3 to 4 months. That is all which might take to settle the dispute or to know the outcome of the dispute, whether it will be settled or not settled. The parties are directly involved, and the settlement is in the interest of both the parties. So it is a win-win situation for both. Both the parties cooperate in coming to a settlement. So we see that it's a collaborative approach. It helps. As a result, there is not much bitterness or grudges against the parties. Finally, it might end up in a friendly way. And so the relationship and associations are restored and maintained in the case of mediation, which might not be there in the case of litigation. So from above, we see that a process of mediation, definitely Mr. Devdas will be taking the advantages in detail, but we see that it is flexible, it is informal, the parties have a direct control, it is economical and time efficient. I may explain this with the help of an example, which will be like we can have just a hypothetical example on this. There are two brothers, James and Frank. Now, their father demises, and their dispute arises with respect to their property. There is a residential house, which is 2-story. Both the brothers are living with their families there. There is a commercial shop and there is an agricultural land. Now, the brothers, the distribution of the property raises some disputes between the parties. Now, Frank, the younger brother, wants to go to the court. He approaches the lawyer. The lawyer listens to his case and he is preparing for the brief. He has to pay the fee to the lawyer. The lawyer explains his property is involved, there will be court fees, etc. And the process has to go. On the other hand, the elder brother, James, said that, let me sit and have a dialogue. Maybe we cannot resolve the matter together. We can we can take assistance of a third neutral party and we can settle the matter. So they go for a mediation. And in this case, they put both the parties, we understand that in case of Frank, he does not have a job. So he was looking for something for a stable income also. On the other hand, James' family, he had 2 elder sons who were married and there was already accommodation problem. Now, when they sat to have a dialogue and talk, they finally resolved the matter within a period of, say, 5 weeks. The resolution was that James would take the shop, the commercial shop, for an earning. He would vacate the house and the elder brother will take up the whole residential place. Plus, James would get the agricultural land, which he could sell and find a decent accommodation for himself in the city. Now, if you compare and visualize this with the proceedings going in the court, all the properties would have gone in the court. That's the first thing. It would have taken long and not necessarily the outcome would have been beneficial or accepted by both the parties. Maybe the other party would have gone into further an appeal. Now, the relationship also would have strained and bittered. But here, the parties resolved, the brothers maintained a good and healthy relationship, and the solution was there. So this is I've just given you an example how we can benefit from mediation compared to a process of litigation. Now, since we've spoken on this topic, we want to know what is the process of mediation, like how does it take place? Any one of the participants, I would like to know, have ever experienced mediation or participated in mediation? Anyone here? So I will now give you a brief without much technical words and terminology. So the process of mediation, first of all, you would like to know what are the basic facilities or infrastructure required. So as I've mentioned, it's a private and a confidential process. What we need is basically a mediation room, a conference room with comfortable sitting for the parties and a comfortable atmosphere for them to interact. Further, there can be a waiting area for the parties. Now, hygiene and sanitization is to be maintained. There can be basic amenities like a washroom, drinking water, tea, coffee, etc. So this is a basic infrastructure we need. In fact, most of the courtrooms are having their own mediation centers or mediation rooms. So what here I want to imply is that it can take place from a comfortable room with all the basic amenities. We do not need too much of infrastructure for the same. Now, what is the stage when a party can enter mediation? What is the stage? Everybody would want to know that when should we go or approach mediation? So please note that mediation can take place at any time. It can take place before legal proceedings are initiated. We call it pre-litigation mediation. And the Act and our judicial system is also promoting it and encouraging it that the parties first, before filing any suit or case, go and have a try at a mediation process. Further, even at the stage of legal proceedings, the parties at any stage of the legal proceedings, they can inform the court and refer the matter to mediation before a judgment or decree is delivered. Any stage means even at the stage, even the evidence, everything, the parties can opt for a mediation, which will always be encouraged. So now, what type of disputes we can refer for mediation? Please note that all kind of civil disputes today can be referred for mediation. That is family matters, matrimonial matters, neighborhood matters, community matters, commercial matters like contract, negotiable instrument, bouncing of checks, workplace matters. Then there can be consumer matters. So there is the whole area of cases which can be referred for mediation. In fact, even certain criminal cases of compoundable nature can be referred to mediation with the permission of the court. Now, we'll come to how the mediation process is conducted. So I've mentioned that it is a structured process and it has identifiable stages. So what are the four identifiable stages is? The opening statement and introduction, a joint session, a private session, which in our mediation terminology is called a caucus also, and then the closing of the mediation. Take just a pause here before I start describing each of the stages. So first is the introduction and opening statement. So in this stage, the mediator introduces or gives an introduction about himself to the parties, like his name, his qualification, his experience, and also makes an effort for an interaction with the parties to form a rapport, gaining some personal information about the parties, like their profession, qualification, and something brief about their family. So it is his effort is to form a conducive environment and form a rapport with the parties. He then gives an introduction about the process. That is, it is a neutral process, it is impartial, it is confidential. So he explains them this helps, by introducing the process and giving information, it helps the mediator to gain confidence and faith of the parties in himself and the system. So they are assured that it is going to be an impartial process and it is going to be confidential. So overall, in this stage, he is trying to establish a conducive environment for the parties for the next stage. He also lays down the ground rules where parties are informed that they have to maintain a decorum of behavior. There has to be no personal jibes to the parties. If anything has to be said, it has to be to the mediator, who can communicate to the parties if they're not very cordial in communicating with each other. So then we move to the next stage, which is a joint session. Here, before I go, we will take an example of a matrimonial case where a husband and wife file their case in the court for maintenance, divorce, and a lot of other cases come with this. We call matrimonial cases as a family package where it comes normally a domestic violence case, a maintenance case, a divorce case, etc., custody. So the court referred the case for mediation. Now, in the opening statement, the mediator will talk to the parties, describe, as I've said, he'll describe about himself, he'll gain some information about the parties, and he will introduce them to the system. Now comes a joint session. The second stage is the joint session. In the joint session, as the name suggests, both the parties are present. Both the parties are allowed to speak and put their case. The mediator holds conversation in the presence of both the parties. and he ensures that both the parties are given equal chance to state facts and put their side of the case. Now, in this session, we gather basic information about the case, about the parties, the issues involved is gathered. The underlying interests of the parties, what are their claims and defenses, are also revealed at this stage, and mediator gets introduced to the facts of the case and the perspectives of the parties. Now, at this stage, it also provides an opportunity to the parties to know. I'll repeat, it provides the parties an opportunity to know and understand the perspective and interests of the other party, because they're talking now and putting the facts and their claims in front of each other. Now, when we took the matrimonial case here, like the wife in a joint session will give all the reasons, like she might state the facts that what were her issues involved. She had a problem with the in-laws. There was a demand of the dowry. She was told there was restriction as to her interaction with her family. Her family was not allowed to come to and visit her place. In spite, she was a working woman, and when she would come back, she had to do the household chores, which was tiring her and draining out on her physical health. She can say that the husband was not supportive to her. He would not take her side, which is a normal statements which the wife, what her grounds and her issues are, can state. On the other hand, a husband may also put his case. He might say that the wife was not behaving properly with his parents. She had a lot of interference was there from our parents' side, and she would not do all her duties as a wife. So all these facts which are uh, with both the parties will be coming up in the joint session, and what they want. The wife might say she doesn't want to stay and she wants alimony. The husband might say that he still wants to give a chance and he wants to continue with the marriage. So with this now comes the third stage, which is a separate session or caucus. Separate session, as it suggests, it is done with the parties privately, alone. This is a very, very important stage and session in mediation. All the stages have their own role to play. But in this session, since it's a private session, the party can share personal and confidential information at this stage. The mediator gets a chance to have a deeper understanding of the case, the party's interests, and what are the position of the parties. What does the party want? At this stage, further, you see that the mediator uses this stage for reality check to the party. That is, he just provides like a reality check here means that he takes the party through a reality testing, that whether the claims, the position of the party is realistic, is maintainable, can be honored by the other party. So I'll describe this with the help of examples. In the case where we were discussing a matrimonial case, now the wife asks that she does not want to continue and she wants the alimony and she wants residential accommodation and some money to maintain her from the husband. In the confidential session, private session, the party informed the mediator that she's a working woman presently, which she had not disclosed to the husband. She informed that she had left, so she needs some support and maintenance. So there were other things, like she said that some part of her assets are with her. So there were many personal information which she could not share, she can share at this stage. Now, the mediator, when she said that she needs a residential accommodation in Delhi, we all can understand that it will cost, it will be expensive. So, mediator had to ask her, does she think that her husband, who was in a very reasonable job, would be able to honor this demand. The wife said that she did not bother, but because her father owns property in Delhi and it is from wherever he wants, he should be giving. Here, the mediator gets through further reality check. He explains her whether it is maintainable in law because it is the property of the father-in-law. If it is self-acquired, she cannot claim it. So it's a reality test where the mediator gets the party to understand that her claims need to be renegotiated or re-looked into. So in this session, further, the mediator encourages the parties to generate options, think of options. They can be workable, they may not be workable, but he encourages them to generate options. Like in this case, we will come to, the mediator explained her that in case if it is not this, what else can be asked for? What will be the best suitable option for you in this case? Which would be a good sum, which can support her for some time till she becomes more stable. So this is the role of a mediator in the private session. That is gaining more deeper information, maybe confidential information, reality testing, and then brainstorming, generating of options. So this is all done. It is not how I'm speaking. It is done by specialized techniques. The mediator will always be asking the positive, affirmative sentences and taking the party slowly to that stage where it can realize that we can go for a negotiation options. So in between these private sessions, I would also mention there can be sub-sessions where a mediator would just like to meet the party's counsel or party's family members. So, and when we talk of flexibility of stages, it is the joint session and the private session which are interchangeable. It will depend on the mediator where he feels that maybe a private session is required before a joint session or a party wants to talk to the mediator separately. But it is a duty of the mediator to make clear to the parties that both the parties will be given an equal chance and this is not to prejudice the process. With this, we come to the closing of the mediation. If parties are able to arrive at a mutually agreeable terms, the same are reduced in writing and read out to the parties. So if the parties are able to arrive at a mutually agreeable terms, the mediator orally recites the terms, explain the parties in their vernacular language, and then if the parties confirm, it is reduced into writing. The parties put their signatures and the mediator then put his own signature and a copy is given to both the parties. As I mentioned, it is the choice of the parties to settle or not settle the matter. At times, a matter remains open. It is not settled. In that case, a mediator will make a report of not settled. In either of the above cases, the mediator makes a closing statement and thanks the parties for their participation and cooperation and gives a final end to the mediation process. So with this, I end the basic general information and an overview of the process of mediation and the concept of mediation. And I will be handing this over to Mr. Betra for further discussion.
Thank you. Thank you. Any questions?
Any questions at this stage?
Madam, there are a couple of
I'm
questions.
sorry, we will take up. Would you like we take now?
There are a couple of questions in the chat box.
Two more out of court. Sorry. So there's a question by Mr. Rajesh Jha. Yes, sir, there is a query by Mr. Rajesh Yadav. We'll address that. My question is, while it could lead to more out-of-court settlements and reduce court backlogs, it might also be seen as an imposition on parties who prefer
other dispute resolution method.
Yes, very, very true. Very true that it's a good observation. But in the beginning of the process, we have said that it is a voluntary process. So please appreciate that at that point I made it very clear that it is the free will and choice of the parties, Mr. Rajesh. There are other ADR mechanisms and the parties are free to choose. We have mentioned very clearly that it is the choice of the parties to settle the matter or not settle the matter. So it is not mandatory. Even if it is court referred or under any act, it is not mandatory and it is a choice of the parties. It has a characteristic of a voluntary process. So I think that should answer your question.
Another question, it's not given. Where is the place of mediation in Indian law system? Does mediation have a formal recognition?
Yes, there is a question by that
Okay.
there is we do not have the reference of the questioner. So that is where is the place of mediation
Indian law system.
in Indian law system and
Mediation has
yes,
formal.
yes, this is very important and good question because now recently we've had mediation is, as I mentioned, it is deep rooted in our social and economic system. It has been moving and it has been incorporated in our legal system some decades back. And today it has a legal recognition with the coming of the Mediation Act 2023. Now, Mr. Devdas will be talking about it. Further, I will like to make a statement that as per Section 89 of CPC, today any case which is registered in the courts has to be referred for ADR mechanism with the choice of the parties, and most preferably, it is mediation in civil matters. And courts are having their own mediation centers. The government is also building up huge infrastructure, promoting and developing mediation on a much larger scale today, in today's scenario.
Agreement has reached to this point.
Yeah, and then there is a formal recognition to it with the coming of the act. And once the agreement is reached, if it is a court annex, it is given a formal recognition with the passing of the decree.
One last question, just from Asir, it says, what is the difference between Arbitration Act and Mediation?
Yes, so that was a question with from Sir.
Yeah.
Yes, sir. So, sir, that was an important question between what is the difference between the Arbitration Act and Mediation Act, which is also a very relevant question because both are alternate dispute resolution mechanisms. Now, here the only it is here when we talk, I talked about litigation versus mediation. But here, when we talk of arbitration versus mediation, arbitration has a very similar footing as litigation because it is quasi judicial but adjudicatory. So it is the arbitrator who has the control of the process and the final outcome. That is one. Then it is as per the Arbitration Act 1996, it has to be followed. There is an award or an appeal. So it is not by the parties, and it is again what we say that it is not in mediation. It is more collaborative. Arbitration can go lengthy because the award can go for a challenge. In mediation, since the parties are themselves resolving, we normally see there is a finality and adherence to the settlement. So it is an arbitration time and again, even our judicial officers are saying that it is more expensive compared to mediation. It is more friendly.
Thank you.
The rest of questions, please.
So that was we really welcome the active participation of the parties. So that's really nice. There are some few questions. If you would want, we can. How many?
The two more would party with more resources may prolong the process. This is by
It's okay, doesn't matter.
Nedar Singh.
So there's another question, if I'm pronouncing the name properly, Mr. Nidar Singh. Nitar Singh.
Party with more resources may prolong the process.
Yes, it's a good observation that like you've said, that parties with more resources may try to prolong the process. So in case of mediation is a very time-bound process. You see, the Act has made a limitation. Earlier also, there was a limitation to the time period. That is, presently it is 120 days plus extension of about 2 months more, that is 60 days more. So once, if it is not, it is because it is an alternate dispute resolution mechanism. If the parties are not able to reach to any amicable settlement or resolution, then the matter is referred back. It is a duty of the mediator to close the proceedings due to the tenure, the time, because of the limitation of the time period. So this factor normally, which is a good observation, cannot be utilized in mediation. That is one of the very important factors, in fact, which is why it is a preferred mode of mediation. I hope it is clear. In case if you want a further clarification, we can do that.
Then there are a bunch of the questions which form same basis. I'll just read one by one. Ma'am, how can I become a mediator as I'm an advocate from Hyderabad? Then is it mandatory to be a lawyer for being considered as a mediator? And is there any official certification or recognition for mediator?
Okay, so we have a bunch of questions where there's query as to the qualification of the mediators. So to be a mediator, you have to undergo a training, a mediator training program, which is mandatory, and many institutions are running it. They are being government based. There are private institutions. So there are many institutions which are running, but definitely it has to be, it is a training process and it is a certified course.
Necessary to
And
be a lawyer.
then, yes, it is always an advantage to be a lawyer, and in quarter next mediations, etc., the qualification of a lawyer is important. But in community-based neighborhood mediations and all, you can have, if you have a background, it is more appreciable.
One last.
Why a lawyer? Because when you draft the agreement terms, you're more well versed with the law.
One last question. I want to ask, can we say that Gram Nyalaya is also a mediation to the Gram Panchayats?
What is the term?
Gram Nyalaya, they are formed under the Act.
Okay.
Gram Nyalaya.
Yeah, yeah, there's a question about that whether Gram Nyayalaya is a form of mediation. Yes, we have already mentioned that Panchayat system was always, they practice the concept of mediation, where the panchas or the nominated heads would decide the matter. So now it has a legal formulation and statutory recognition, and there is a procedure and guidelines to follow it. That is the difference.
There's one more you want to take, or tell them to take it now, keep
Now,
it following. There is one more.
Yeah, I know, but then I think.
So you can announce that we'll take the.
So we can take. Any other questions also, kindly be free to put them in the chat box. If there is not much clarification which I could give on these queries, we can take them up after the session of Mr. Devdas.
I can briefly answer this question about cost and the duration. Is that okay?
Hanji,
Yeah.
please.
So the question is, what is the length of certified mediation course and what are the costs involved?
Yeah, right. Okay, good afternoon. So, Reverend Nasir has got his hand up. So you want to say something?
Yes, Mr. Bertram, I just wanted the participants to also keep in mind that outside formal litigation processes, outside formal disputes, like what examples were given, participants can also bear in mind that they can use these skills in their day-to-day functioning also, even in contexts where there are no disputes. So you can think of referrals of people in your own churches, in your own institutions to the mediators, even before the litigation process begins. You can also become a good mediator in the way you conduct your committees. These are
Sir,
some things that you should also keep in your mind as part of skills.
Sir, yeah, I would reaffirm on this. This is a very important point which you have made. In fact, in my experience, we've had co-mediators who sit with us, and they have come and told us that it makes the mediation training makes a tremendous difference in their personal life, in communication skills, in dealing with day-to-day life. So this definitely I reaffirm very strongly your statement here. Yes.
Okay, good afternoon. We'll come to the second part of the presentation, the advantages of a mediation process and the salient features of the Mediation Act 2023. There's one pending question I saw by someone who asked, what is the duration of a mediation training program and what are the costs involved? So I can say very briefly that it varies. A lot of the training programs are conducted by a court. Some are by private institutions, some by a state government. Typically, the duration is 40 hours. 40 hours for a mediation training. I know one institute which only conducts online, so they have a 20-hour training program, but largely it is 40.
It is normally.
And the cost also varies. It could be 5,000 for the whole course, or it could be 10,000. So it varies. It's not very expensive. There are some which are less expensive than that even. So to answer that question briefly is 40-hour duration, cost, I would say 5 to 10, not more than that. Okay, can I proceed now to the advantages? To give a small background, conflict resolution over the years has been largely through the court. So it is adversarial in nature, and there's conflict between the two parties, and a decision is made either way by a judge. So one typically loses, one typically wins. Now, apart from litigation in court, the alternate dispute resolution mechanisms they include arbitration, conciliation, which is now part of mediation after the act, lok adalat, and negotiation. Out of all these alternate dispute mechanisms, arbitration is again adversarial because there the lawyers argue on behalf of the clients who are also present. It's based on evidence which is adduced, and normally a retired judge or a senior lawyer becomes the arbitrator. So it is quasi-legal, and the decision at the end of that is made in the form of an award. So it's an arbitration award. If it has been referred by a court, it goes back to the court and they have to either uphold it or reject it. The parties have less say in this process. But mediation now, and this is the major advantage of mediation, is that it is non-adversarial and that substantive law and procedural law, they do not strictly apply to a mediation process. Now, procedural law would be like the CPC, Code of Civil Procedure, Code of Criminal Procedure, and substantive law would typically be Company Act or the labor laws or the Indian Penal Code. So these, as I said, strictly do not apply, including the Evidence Act. So the first point that has already been made earlier is it is a voluntary process. It is only when both parties agree to submit to a mediation process that it can happen. In a court of law, if one party approaches, then a notice is sent to the other party and they have to appear. In this case, only if both the parties agree, then the mediation process begins. There are certain mediation service providers who have a mediation panel and they recommend a mediator out of that panel. In some cases, the parties themselves are free to choose a mediator and go ahead with the process. Now, in this process also, a party can opt out of the process at any time if they're not satisfied or for whatever reason. and the mediation process would then come to an end. The second advantage is that it is a flexible process and a simple process. So it flows from the first point that since we're not bound by so many rules and regulations and the law, it is more based on the principle of natural justice. And the mediator will try and assist. He will not take a decision on behalf of the parties. He will assist the parties themselves to come to an agreement and then sign a settlement agreement, or in case there is no possibility of an agreement or is taking too long, mediator feels there is no point in continuing beyond a point, then a settlement report is prepared. Mediation can be court annexed, which means the mediation center is on the campus of the court, whether it's the Supreme Court or the high courts or the lower courts or the trial courts. So the cases which are being heard in that court are sometimes the civil cases are referred to that mediation center. So the lawyers who are enrolled in that bar with, say, 10 years of experience, they can enroll themselves as a mediator after taking that training. And they will then try and form a settlement report, go back to the court for its endorsement. But largely mediation is private. So parties themselves can decide to approach a mediation service center, and there are plenty across the country. The state government of Delhi runs a very successful center and process, and that is largely approached by many people. The third advantage is informal. So unlike a court of law or even in an arbitration setting, this is more informal, as has been mentioned just now by ma'am. All you need is a small conference room with a table large enough to take both parties on either side. Parties sometimes prefer to bring their own lawyer, which is okay, but the lawyer in this process plays a secondary role. It is the parties who have to talk and negotiate and finally come to an agreement, or to say that no, we don't agree. One of the most important features and advantage of the mediation process is confidentiality. The matters that are discussed in a mediation process are not to be divulged outside. It is remaining within the four walls with the mediator and the two parties. In case the matter is referred back to the court cannot ask them what happened in the mediation process. The parties are not obliged. In fact, they should not say what happened in the mediation. The mediator himself or herself cannot be summoned by the court to give a report and to say what happened. That is also not allowed under the Act. And therefore, the parties know that whatever they speak, they can speak freely without being quoted in a court of law or outside the mediation process. Therefore, what we can gather, the next advantage flows that it is the parties who are important. Any mediation process is party-centric. And therefore, without the parties coming to an agreement, there will be no mediation settlement signed, which is generally drafted by the mediator, but shown to each party and explained to them. And only when they agree is the report signed. So far, is it okay? Am I going too fast? Any quick interjection? Can I go ahead? So,
Yes, please.
So we also know that it is participative. The parties, they are drawn out, their feelings, their thoughts are drawn out by the mediator through a specialized technique. The first meeting, it's possible that they are shy, they don't bring out whatever they want to say. But the second or third hearing, by that time, they're a little more familiar, comfortable, they would start speaking more. And has been said, there are joint sittings, but there are also cases where one party is asked to remain in the room and the mediator speaks to them confidentially and separately. And generally, then parties speak their mind, and the same opportunity is given to the other party. And once the mediator knows what is exactly in their mind, what is their underlying the factor behind what they are saying, it's easier for him or her to then bring them back together and say, look, I feel this is how you want to go ahead. What do you feel about this option or that option? And then they get to talk about that. The next thing is it's a fair process. Both the parties are given roughly equal time to speak. They're given ground rules of not to try and bring the other person down. There are no put downs allowed. People have to respect each other and the mediator. And in turn, the mediator respects both the parties and appreciates whatever is being said and then tries to bring them around to some common platform. As is abundantly clear by now, communication is very important in any mediation process. There has to be open communication. There has to be a free flow of thoughts. People are encouraged to speak their mind, and they know that since it is confidential, whatever they say is not going to go out. Another very important area is relationships. In a court of law, one party typically loses, the other wins. But here it is building of relationships, restoring of relationships, where it is a win-win situation. I can see someone's hand raised. Sir, would you like to say something? You'll have to unmute. I can see a hand raised. It just says Samsung SM. Yeah. Does it? Okay, fine. Okay. So I was saying that relationships are restored, they are maintained, because at the end of the day, both parties are supposed to be happy with the result. Each gets something, a pie, a share of the pie, and therefore no one feels that they've lost whatever they could have got. The other party cannot feel that I've got everything. So underlying the whole process, the parties' interests are taken care of at each stage. Whatever they have in mind eventually has to come out in the agreement. It is also abundantly clear by now that this is a mutually beneficial exercise because both are going to gain something out of it. Once a process has come to an agreement stage, it is called a settlement agreement, which is drawn up by the mediator, shown to both the parties, explained to them in their local language if necessary. Once they agree, then the parties sign. If the lawyers are with them, they are also invited to sign. And then only the mediator signs to make it final. On the other hand, if there's no agreement, or people feel no, they want to go back to a court of law, then a non-settled report is signed by the mediator and the parties, and that is taken back to a court, or they can go to a consumer court or wherever else they would like. Creativity is another aspect which is important because here it is a free flow of thoughts, of discussion. There might be a creative solution which may not be possible in an arbitration proceeding or in a court of law, where a party might suddenly come up with a new idea, or the mediator can, after talking to them separately, think of something new. And that can lead to a fresh line of thinking and a new way of settling it. Compliance is important because once the agreement is made, both parties are supposed to comply because that is binding under the Code of Civil Procedure. And both parties cannot go back and say, now we don't agree, we have to open it afresh. Because there is one clause generally in a settlement agreement that both parties are satisfied, all issues have been resolved, and that we do not intend to go back to court to resolve our dispute. And therefore, there's a finality to the agreement, because once the agreement is signed, that is final and binding on both parties. One important thing is that there's also a possibility of refund of fees. Supposing both the parties have appeared in a court of law and they have paid the court fees, if they've been referred by the court to mediation and mediation has been successful, then the parties can inform the court, and the court will generally be willing to refund the fees paid. So that is something, another good thing for the parties. So I've come to the end of the advantages, and I will pause here for any quick interjections or any questions. I saw a comment that he's found the presentations insightful so far. Thank you very much. May I proceed? So the courts themselves are now pushing matters, matrimonial disputes, other civil matters, to mediation. And in fact, last year in the High Court, Justice Pratibha Singh had passed an order that, in essence, the obligation to attend mediation is of paramount importance. It is a mandatory step to be taken before commencing litigation. This is in a case between a national insurance company and another commercial body, and she pulled up that insurance company for not attending the mediation process. So courts are also now veering around to the view there's so much a backlog of cases, it's a costly process, complicated procedures, that mediation is a very easy way out in comparison. As ma'am has said, the Supreme Court has recently also said that we should take mediation process to villages. Panchayat, of course, is a traditional way of a mediation process, but this would be relatively a little more structured and hopefully out of the caste-based situation we normally find ourselves into. The final area is briefly the features of the Mediation Act, which has been brought out in 2023. We are still awaiting the Mediation Council to be formed, which is a statutory body where mediators and mediation service providers will be empaneled. But even apart from that, it is brought into sharp focus that this is a very easy way out for resolving conflicts and disputes. The scope of the Mediation Act includes disputes in civil, commercial, and matrimonial matters. The other thing is that an agreement is signed, as I've already said, at the end of the proceedings, once both parties have agreed. If there is no agreement, a non-settled report is also signed. The time limit, as we mentioned, is 120 plus 60. So within 180 days, that is 6 months, it is envisaged that most disputes should be resolved. In certain cases, it may go on longer. But compare this with a court process where it could take 10 years, 20 years or more, and it is dragging on. So this is a much faster way of resolving a dispute. As has been mentioned, one of the features in the Mediation Act is confidentiality. There is no audio or video recording permitted, and no evidence or information given in the proceedings is permitted to go out of the room. Admissibility, as I've said, no mediator can be compelled by any court to reveal what has happened during the mediation proceedings. Now, the fees, a common question is, what are the fees that a mediator can charge or what the parties have to pay? Now, this again is variable. It depends from mediation center to mediation center or in a court. The parties may pay a negligible amount if it's in the case of, let's say, the government of Delhi. In a private mediation process, it could be 5,000 per sitting per party, it could be 2,500. It all depends. The mediator also may charge a high amount if he is very senior and reputed. But in most cases, it is a reasonable amount. So the mediation fees also would typically not be too high, and they would be shared between the two parties when they pay a mediator. The enforcement also, I've said, one of the features is enforcement of the agreement. This can be enforced as a decree of a civil court. There are certain matters that are not fit for mediation that is given in Schedule 1 of the Act. And here, for instance, any matter regarding minors or deities or those who are, let's say, mentally challenged, special ability, or any criminal offense, anything to do with public interest or to election to a public office, such matters are not fit for mediation. They're beyond the scope. Advocate Mary has given a comment that mediators need to be unbiased so that their clients are not influenced. I just read it on the screen. Thank you, ma'am. That's a very good input.
It is a feature of mediation.
Yes, and
It is an inherent feature of mediation.
yes, and it's also a feature of mediation. Thank you. As I said, Mediation Council is envisaged, which still needs to be formed. We need to get that done soon. They'll have training programs. They'll promote mediation in a bigger way. They will impanel mediation service providers and individual mediators. Community mediation is also provided for in the Act, and that is already happening. There are a lot of these, for instance, in a, what is it called, in a locality, the Welfare Association, the Resident Welfare Association, there are cases where sometimes a panel of mediators are asked to go and mediate on a dispute among the residents. Then online mediation is also gaining ground, virtual or e-mediation. That is typically important when people are living far away or even in another country. It's difficult to travel. So that's where it's very important. So online mediation, community mediation, of course, in person. We feel that mediation is going to be a bigger thing in the future, and it is a good time for us in our institutions to then go ahead with this. Someone is asking, do we have to register ourselves with the Bar Council?
Not that, how would people know that you are available and can be?
Right. So Bar Council, we do not have to be enrolled because that's only for advocates. But a mediator, as I said, will eventually be enrolled with the Mediation Council whenever it is formed, should be soon. Apart from that, mediators or mediation service providers can do their own publicity. There's no bar on that.
They can have a panel of mediators. Please, sir, you.
No, you can go ahead.
Go to. And you.
So the panel of mediators, I mean, they're available all over. And
The courts are having their own.
as I've said, the courts, each court has their own mediation center. Service providers also can put up on their websites.
They put.
You can check on the internet, mediation service providers, you'll get a host of them. Right, so we've come to the end of our formal presentation. We have a few minutes for question and answer. I would request Reverend Asir Ebenezer, sir, to please coordinate the question and answer session. Sir.
Thank you, Mr. Bertram and Advocate Mona. Is there anything else that participants would like to raise? You can use the raise hand option. Can a person from any background become a mediator?
Yeah.
can a person from any background become?
Yes. Yes, this is a general query which any person from any background can become a mediator, which is also stated in the Act. Now, it depends for the empanelment of a mediator. But as we have mentioned earlier, you have to go through a training process because it is an assisted negotiation process where specialized techniques are used for the mediation. So the training process is important. However, the service providers and the courts will have their own qualification to impanel a mediator. Like in courts, it is necessary to have a law degree. That's the only it is. But a person from any background, which is very specified in the Act, also can go for a mediation training program.
If you become a mediator, you need to go with the bar.
That's okay. Any other queries?
Anything
We need
else?
to have any registration done for that to be a mediator?
Yes. So you would like to
Yeah,
mention? Registration, sir, as sir has mentioned that now mediation, after the coming of the Mediation Act, the government is wanting to formalize the whole process. Earlier it was, so it is already mentioned that there has to be constitution of the Mediation Council where the mediators are supposed to be registered, but the formation is under process. It is still not notified. That is a difference. However, you can have, once you have the training and you're a certified mediator with a certificate, you can write it in your um, visiting card or your professional profile. It can be mentioned. And as sir has mentioned, if you are empaneled with any of the service providers, whether government or non-government, does it make it clear, sir, your query?
Yeah, it's clear because, this has a lot
Anything
of,
for?
Thank you.
this has a lot of
Anybody else?
legal implications too. That's the reason I asked, because we need to have a registration.
Yes.
Yes,
It,
that possibility. Yes, that requirement is there. Not everybody will be recognized as a mediator. Of course, we can mediate, but to be recognized as a mediation process under the Mediation Act, certain qualifications, certain processes are stipulated.
But
Ma'am.
but from any background, it can be done. And sir, I'll reiterate your statement that the mediation training is tremendously helping in everyday skills and life, which was a very important statement, which I also I missed out on it, which you have made. And for community mediation, neighborhood mediation, etc., people might not necessarily come from a legal background. So there are qualifications related to that in the Mediation Act. There's a separate section for community mediation.
Yes, Madam, I also want to ask you to share with us that certainly there are some areas where the Mediation Act does not have jurisdiction, particularly issues relating to POCSO, Juvenile Justice Act,
Yes.
rape, murder. So can you throw some light on that as
Yes,
well? We
yes,
can't
sir.
assume that everything comes under mediation.
Yeah, actually, I covered up in my earlier lecture that which are the cases which will come under mediation, where I've specified that matters of civil nature, all matters of civil nature are covered under mediation unless there is a specific bar on it. And criminal cases are not covered under mediation. It is specifically being mentioned in Schedule 1 of the Act now. Yes, sir has also mentioned. However, it is mentioned as per Section 6 of the present Act. Certain compoundable offenses of petty crimes of petty nature, which are there in our BNSS Act, can be, with the permission of the court, they can be mediated.
Check bouncing.
Yes,
Legal.
we mentioned, yeah. Yeah, so sir, criminal offenses of grave nature like rape, murder, dacoity, kidnapping, etc., definitely do not come under the purview of mediation. But in case like a trespass and maybe altercation and all, are permissible now under the Act, and previously also they are known as compoundable in offences where parties can come to a settlement.
Yeah, I refer to the comment made by the question raised by Mr. Amol Parage about the usefulness of this knowledge by the frontline missionaries. Yes, Mr. Parage, I think it is important for them to recognize that such a thing is there, so that they can always ask to be referred to Mediation Act. But that that's one thing that we need to know. If there's no other intervention required, I would use this occasion to say my closing words and thank each one of you for being part of this process. This is only a beginning, as I mentioned to you at the start of this webinar, that this is an introductory webinar. That's how we view that. Many of us may not have known that such a law exists at all. In fact, I did not know till such time Mr. Bertrand brought it to my knowledge. We were always thinking of Arbitration Act, and when we always had a clause in our constitutions on arbitration, and then encouraged each of our constituents to incorporate that. This is something that we thought is very important, even outside the larger framework of our institutions, both for our own selves, our own formation, our own ministries, our own work. This can be used in several places. It could be used in our workplace. It could be used in our churches. It could be used in our classrooms. It can be used everywhere. I recognize the presence of principals here, registrars of colleges. I also want to recognize the presence of Mr. A.B. Sundarraj, the founder president of Christian Institute of Management. He has been at the forefront of ecumenical movement and church union negotiations, and has been an ardent campaigner of transparency, accountability, and responsibility in Christian institutions. Thank you, sir, for joining us. I would like to suggest that we work on receiving feedback from you on what you would like to see in your own institutions with regard to Mediation Act. For example, you would like to train a number of people in your own churches, in your own institutions on this. You would like to train your pastors. You try to train your theological educators on this. Do write to us. I will ask my colleague to type the NCCI email ID here so that you will know that. Do write to us. If you know our communication broadcast group number, do write to us on that number so that we will have the follow-up appropriate to what you want. As far as we are concerned, as I mentioned to you at the beginning, we are hoping to have a group of trainers across the country. I see people from Himachal Pradesh down to Trivandrum. I see people from the signed in from the Northeast India. So I suppose we should have trainers from across the country, and then at some time trained and accredited mediators who will assist in this great process and help people have a harmonious living in their own context. Training for Orissa is needed. Yes, Bishop, we will try to do that. Do write to us. ncci@ncci1914.com, all in lower caps. And you will see in the chat, that is our broadcast number. You can save this number as NCCI communication in your phone. And if you are not already connected, you send a message to be connected. Unless you save this number as NCCI communication in your phone, you will not receive our messages. Sorry, we will not be able to send any good morning, good evening to you. I'm sure you have enough of that on your phones. We will also not send you any Bible verse. You also get quite a bit of that. You will receive only what NCCI shares in the public domain, like notices of these useful information. You may also like to refer this conversation, which is on YouTube. Today it was live streamed both on YouTube and Facebook. And if you would like to refer that to your friends, you are most welcome. I'd ask my colleagues to put our YouTube channel name also in the chat. Thank you very much, Mr. Bertram and Advocate Mona, for taking us through this time and introducing this. It's a very important tool for us, particularly the Christian community is seen as a community that works on reconciliation. And oftentimes we lack the tools and the skill. And this is one such thing that you introduced to us. And we are grateful to you and request your accompaniment as we take this forward. I want to thank Ananya for her time in assisting in doing this webinar. And I also want to thank my colleague Neelam Gaikwad for being in touch with Mr. Bertram and preparing for this conversation right from the beginning. Thank you to all church leaders who have been part of this conversation this morning. I also saw Cynthia. If you're still here, thank you for joining. Cynthia Stephen is a journalist and ecumenist. She also contested on an up ticket in Bangalore, in Karnataka. We are happy to see you here. If there's any way that we could take this forward, do let us know on our communication channels. Thank you once again. Thank you all. Have a great weekend.
So thank you so much for all your support and inputs. Thank you so
Thank
much.
you.
And
Thank you.
thank you to all the participants.
Thank you.
Thank you.
See you.